All right, I think we're going to go ahead and get started. We've got most everybody here. Just a reminder that this is being recorded and will be available after the meeting as well as the PowerPoint. So welcome. This is our second meeting of our PCRP advisory group. And we are going to dig in today. Can everyone see the PowerPoint? Okay, perfect. So real quickly, we'll go over our agenda. We want to talk about I know we went over these at our first meeting, but we'll go over the advisory group goals and objectives again, our ground rules. And then we'll turn to our finalized list of topics. We discussed the topics at our first meeting and came up with a list. We actually sort of came up with two lists. One is our list for the first 4 meetings of this group, which really are all related to contract language, revising contract language. And then there were a few other suggestions, and I'll show those as well. And then we're going to dive into our first topic today, which is pre-petition representation. And then potentially get to a recommendation if there is a different recommendation for pre-petition representation. So objectives are to identify the PCRP juvenile contracting challenges and any needs for improvement, engage in our case manager OPDS provider conversations to explore issues and refine program contracting model accordingly, and then refine and update programmatic components for the upcoming contracting term. In our ground rules, we want active participation. Everyone should be speaking one at a time. Everyone's been great about that. Be candid and respectful in our comments. Stay focused on topic or question. I'll do my best. Active discussion does need to be limited to these meetings and shouldn't take place over email because of the public meetings law. And then OPDS staff, we are going to try to limit our talking to a minimum. This is really mostly for you guys to share with us your thoughts. So our finalized list of topics, the first 3 are ones that the OPDS had suggested our first meeting, and then the 4th topic was a new one that was proposed last week. So pre-petition representation is what we'll start on today. Complex case weighting. Topic 3, understanding the case manager role. And then topic 4, attorney capacity and availability, which is definitely another important one. And we'll talk at the end of the meeting. We'll go over the next 3 meetings that we have scheduled, where we'll talk about. So essentially, we've got 4 meetings currently scheduled and 4 topics. We may or may not get through all of this in the 4 meetings. We can always schedule more meetings later if we need to. This is the short list of other topics that came up last week. You'll likely recognize these. These are items that aren't necessarily related to contract provisions, but are things we that certainly may want to explore in the next round of meetings. So our goals for today: we want to start the discussion and review of pre-petition representation. We're going to look at the contract definition and sort of our working eligibility determination. We'll go over some examples of requests that we've approved and requests that we've denied. And then Gloria has put together some data on the case reporting trends. Up to this point, we haven't spent a lot of time looking at pre-petition representation. And it's clear to us that there's potentially a few inconsistencies in how this is being tracked. So we have some suggestions on that, but it does give us some helpful information as a starting point for, how often are folks requesting pre-petition, in which counties. There's some counties that either aren't doing pre-petition representation or at least aren't tracking it on their reports. And then take a look at whether there's additional information we need before we can make a recommendation and potentially get to a recommendation by the end of our meeting today. So let's dive in. Pre-petition, this is the contract definition. You will likely recognize that. Pretty basic. Pre-appointment juvenile representation means representation of a parent or a child during a DHS child welfare investigation before a proceeding is filed. And then our in-house working definition guidance is in dependency cases, authorization for pre-petition is typically limited to representation of a parent custodian who is the target of an active DHS assessment or investigation. And we've tried to be as consistent with this as we can. What we've realized over the months and, now a couple of years that we've been reviewing these requests is that there may be ways that we can expand it that make more sense. We've certainly heard from some of you in that regard. And so it's going to be really helpful for us to hear more from you. But before we get into those discussions, I'm going to turn it over to Gloria to share the data that she's pulled together. Oh, sorry. No, actually, I wonder if it makes sense, Gloria, for us to look at the data first and then.
Whatever you want to do, I'm ready.
Okay, let's do that. I'm going to button forward to the data and we'll come back to the examples.
So I used the attorney reports from last July through June of this year to try to figure out what is the scope of pre-petition representation in the current PCRP counties. And in doing that, I realized that there are a lot of probably data entry issues with pre-petition. So that's a separate issue than we can address in this meeting today. But when we're reviewing these numbers, I just want you all to remember that these are like the best we could do with the reports that we have, but they're likely not going to give the full picture of pre-petition and likely are underrepresenting the work that the PCRP attorneys are doing on pre-petition representation. So the first thing that I looked for is how many distinct pre-petition cases the PCRP attorneys have worked on over this 12-month period. And in looking into that, I found about 51 unique pre-petition cases in the PCRP data. And this represents 12 months for the existing counties, but only 6 months of data for our 4 new counties. So that's one way to look at this. But what we see is that clearly Columbia and Multnomah counties are tracking the most pre-petition cases. Likely they are working on the most pre-petition cases, but that's certainly what we're seeing in the data, that they're having the largest volume. So in the next slide, we are looking at how this breaks down for workload. So not looking at distinct cases any longer, but looking at the proportion of workload that's made up by pre-petition over this 12-month period. Again, it's only 6 months for the new counties, but it's the same analysis. So when we look at this proportionally, we see that Columbia County is clearly has the highest proportion of pre-petition cases at over 2% of their workload in this 12-month period. For all counties, this averaged to 0.3%, so it's very minimal for overall counties. Lincoln and Coos also had higher than average, and then we see that some counties don't have any pre-petition cases that they've worked on in this 12-month period, or at least not that they reported. And then in the next slide, this is looking at the activity time spent on pre-petition cases, just to get a sense of what attorneys are doing on pre-petition cases and how that compares to cases that are actually filed. And it's probably not surprising to anyone, but the pre-petition cases don't have a lot of court activity compared to the cases that are filed. So we're seeing about 2/3 of time are spent on other casework, and about 1/3 of time is spent on client contact for the pre-petition cases that the PCRP attorneys are tracking. And then I think the next is the last slide. So in this analysis, I was trying to get a sense of how many or how much time PCRP attorneys are spending on pre-petition cases compared to cases that are filed. And so what this analysis looks at is by county, how many monthly hours were spent on each pre-petition case compared to each filed case. And so what I saw is that across the 10 counties, attorneys are spending on average about 1.5 hours, 1.4 hours per month on each pre-petition case, and 1.6 hours per month on each non-pre-petition case. Say non-pre-petition case or filed case, they're the same thing. I don't have the right language to describe this right now, but essentially the time is pretty much the same for each of these case categories. So we're not seeing a lot of difference. Again, this is also like we're not sure if the PCRP attorneys are really tracking all of their time on pre-petition cases. So I would say it's likely an undercount of time on pre-petition cases. But again, this is the best we could do. And I thought it would be a nice level setting for the discussion. So if people have questions, I'm happy to field them. I may not have the answers, but I could write them down and get back to you.
Any questions or comments about the data? I'm going to go back to our examples. So I wanted to provide a couple of examples of when we've approved pre-petition, and these are pretty generic, obviously left out any specific details for confidential reasons, but the first example is pretty basic. PCRP attorney represents a mother in an open dependency regarding child 1. Child 2 with a different father is still in the home with mother, but DHS has begun an assessment into mother's ability to keep child 2 safe in the home. Mother asks PCRP attorney to represent her regarding child 2 in an effort to prevent a petition being filed. So this is a situation where the current client, the mother, is the subject of an open investigation. And so really that could be claimed as pre-petition without a specific request. That's probably like the most obvious approval. I mean, it's certainly fine to reach out to us for approval, but I think we've had people report these on their caseloads without specific email authorization. Sorry, bouncing. Any questions about that one?
Hi, this is Stacy. I did have a question about that. I want to make sure I understand correctly, because I would think that would not result in another case credit, so to speak, for lack of a better way to phrase that. And so, because if the case had opened originally with both kids, you would represent mom and it would count as a 1. So correct. I guess I'm a little confused about why this is in this section.
I mean, it could, the reality is it could, and I guess this is where I'd want to hear from some of you. It's possible that some attorneys would just consider this part of their underlying representation and wouldn't necessarily, reach out about pre-petition. When this has come to our attention, and I guess that's sort of where I'm saying it doesn't really need pre-authorization, because you either are going to claim it as part of your underlying case because you're you're already representing mom. But technically, if it would result in a new petition that isn't yet filed, it could be claimed as pre-petition. I'm seeing heads nodding. Does that mean most of you are claiming it as your underlying representation? Warren, I see your hand up.
I was just gonna say that, I mean, the rules for case counting, if a new petition were filed, the petition on that new child would count as a case count until it was resolved, at which point it would drop to 0 if it was a younger child. So doing pre-petition work on that child, it would make sense that it would result in a case count.
Yeah, I think that's accurate. Gloria, correct me if I'm wrong, but that is how we would do that if the petition were filed, correct?
Well,
I mean,
so
depending on disposition.
yeah, our case counting guidelines, which are not the easiest to follow in the situation, would be that if there's a child whose case has reached disposition or jurisdiction, sorry, and a new petition is filed, then you would count each petition until the new petition reaches jurisdiction. So if they're in different case stages. And I haven't fielded questions specifically about how to count the pre-petition representation in this scenario that Caroline has described, so I don't have a response to that right now.
So Judah, I see your comment. You've indicated that you've done this and not claimed if a new petition was not filed. So meaning you didn't claim pre-petition?
Sorry, I'm eating a big sandwich. That's why my video is not on. I have assisted clients when there are open investigations about, so oftentimes when a new baby's born, and I don't claim until the petition is filed. And if one's never filed, then I just treat it like ongoing representation.
Yeah, and I mean that answer doesn't surprise me, although I mean you could certainly claim it as pre-petition if you're doing separate work. I think part of it comes down to how much time are you spending. I mean, in Gloria's data, you can see that for the pre-petition matters that we were able to pull data on, where people are claiming their activities, it's roughly the same amount of time. So I guess that's kind of maybe the question for the attorney for purposes of reporting it. If you're doing something on a day or two and it's not going to be work that you're continuing to do on an ongoing basis, that I can see how that you could easily see that as part of your ongoing representation and no need to file a new, ask for a separate case count. But Amy, you had your hand raised and then you took it down, is it not?
Well, I'm sure we'll get to it later. Thanks.
Okay. Anyone else want to weigh in on this? The second example is a little different. PCRP attorney represented mother in a dependency that closed 9 months ago with the child returning home. New allegations of domestic violence with mother's new boyfriend have surfaced, and DHS has begun an assessment. Mother reaches out to PCRP attorney for representation in an effort to prevent a new petition being filed. Whoops, Alan, you look like you were saying something, but you're muted.
No, I was commenting how obvious that one was. Never mind.
Yeah, again, fairly obvious. A little step down from the first one, but people are reaching out to me on these, and that seems appropriate. But again, it's a former client where they are the subject of an open assessment. So that pretty squarely falls into the definition and our guidance. Couple of examples of denials. DHS reaches out to PCRP attorney asking them to represent a youth whose father recently passed and mother is temporarily out of the picture following previous DHS involvement. Youth is living with a family friend of the father. DHS believes youth's current living situation is best for the youth and suggests the guardianship would be the best way to ensure that there is no disruption by mother. DHS asks PCRP attorney to help with guardianship as they don't believe family can afford an attorney. So I'm guessing, you know, again, this may seem fairly obvious as to why we wouldn't be able to approve it, but we do actually get a fair number of requests around guardianships. And this certainly isn't meant to imply that the guardianship's not appropriate or that it's not, you know, it's not the best method of dealing with the situation. It's really meant to say that because currently there's no apparent assessment or investigation, including for this custodian, you know, we haven't been in a position to approve these. Alan, you have your hand raised.
Yes, this just came up a couple of days ago. I got a phone call from the Attorney General over here, or the AG that does our county. They had a family where mom has a restraining order, dad hired a lawyer to contest it, and they wanted to know if dad gets the child, they'll file a petition because he's, you know, a bad guy. And they wanted one of us, or you know, if we would do pre-petition, which they knew about it, to help the mother prepare subpoenas and that sort of thing, which I think temporary representation would be even iffy at that point. But that whole point there was that if he wins, we're filing a petition. And I told him I'd look into it. I haven't called you about it yet, but this reminds me that that's an issue here right now.
Yeah, so it sounds, so in that situation, you're saying technically father's not the subject of the.
No, mother is not. Mother's protecting. But
Right.
if dad wins the restraining order and is allowed or required, enforceable to court to have parenting time unsupervised with the child, then they will file a petition. So they're looking at doing it if something else happens. So wanting us to avoid that something else. I told her I wouldn't go to trial on a restraining order violation or restraining order case. But you know, as far as like even telling her how to do a subpoena, I said that wasn't a big deal as far as I was concerned, just in my office.
Yeah, and you know, you should definitely reach out to us on that, because I think that's where there's a bit more gray area there, right? In terms of what's going to happen. It sounds like there's certainly a threat of a petition. That would involve, I mean, obviously where the parents would be the subject. I mean, one or the other parent would be the subject of the petition or of the investigation. Stacy?
I was told it was a guarantee. There will be a petition.
Yeah.
Yeah, so I just wanted to throw out there, a couple years back, I had a very similar situation, reached out and was given permission to represent my client. And I did represent her throughout the restraining order process, and we were able to get the restraining order and prevent an escalation out of mother's care.
Yeah, no, I think that's right. I don't have that example here. But that's, again, there's lots of variations. I mean, we have seen a number of different requests that, you know, that can be presented different ways, different parties. But I think those are, you know, those are the basic questions. Is there a threat of a petition? Currently, it's, you know, we've sort of tried to limit it to the parties that representation of parties that are the subject of the assessment or investigation. But I do think, you know, we're open to exploring, you know, potentially expanding that. I don't think we're ever going to be in a position to be able to authorize representation for guardianships where the individuals aren't, you know, where there isn't an active investigation or assessment. But Amy.
Thank you. Maybe now is the time to ask my question. I'm still stuck on the internal guidance, which refers to parents or custodians, and the contract definition, which refers more broadly to parents or children. And so at our office, we've sought authorization in a few cases where he represented children. And I think mostly have been denied, although not every time. And I'm curious if there's specific guidance about the child piece of this. It seems to me if the parent's under investigation and there's a threat of a petition and the child wants advocacy to stay in the home or to stay with the parent or whatever it may be, that would still fall within what you're talking about. But one of the things my office asked me to try to figure out was some clarification around that piece because we haven't seen that yet.
So you're talking about specifically the around.
Yeah, around
representation of
children.
the
Yeah, like
child.
how do those fit in? Or maybe you're going to get that on the next slide.
No. No, actually, I've only got 2 slides of examples. So these are it for the examples. And part of it, I mean, partly, Amy, it's because we don't really, we don't get a lot of requests for that. And so, you know, I think that's an area we need to explore. Again, I think, and Shannon, I know Shannon's on here and she's welcome, certainly happy to have her chime in. We've got a couple Shannon, so to make sure we're talking about the right Shannon. Shannon Getman, you're off the hook. I'm not calling on you.
You can take that. We talked about this. I don't know this because since I'm new to this position and, you know, been involved with PCRP some in the last year, but I don't know the specific examples that you're talking about. So it's hard to in this moment sort of think about what guidance might look like that's more specific. You know, I think it would be looking at, you know, I feel like the conversations that we have in trying, they're in that gray area and really like a close call are really looking at the specifics and what's the threat, and is it like this very speculative threat that's something that you gonna pursue an investigation, potentially file a petition, because that's really, I mean, that's the idea, is to avoid the filing of a petition. So I don't think it's obviously, I mean, children are included in the contract language here outside of the realm of possibility. We can certainly work on coming up with guidance. I think we're trying to collect these examples of when we've approved and when we've denied in that gray area to try to be developing more specific guidance to be helpful. But I think, you know, the best that we can tell you right now is to continue to reach out, particularly in child cases, because I think a lot of those are either they're going to be a denial or they're going to be in that gray area. So I think those are appropriate as we continue to.
Thank you. And even that, Shannon, even that's helpful. Just the idea of thinking about avoiding the filing of a petition and the construct around that. So I can at least bring that back and we can work toward that. Thank you.
And that's really how I think of it is, can we end up with sort of, you know, state savings, but not just that, but really, you know, benefit a family who's going to end up in the system and need a lawyer, and you've got much larger costs, both financial and otherwise, associated with a full dependency case where if we can, you know, ameliorate the risk of that happening, then that's fine.
Yeah, and I know we have some hand raised now, and I'll try to call on you in order in just a second. But along those lines, first of all, I just wanted to clarify, Amy, I know you were referring to kids in a dependency case. Obviously, we haven't talked specifically about youth in a delinquency, but I think those are pretty obvious. If you have a youth client or former client who's being questioned, I mean, there's, you know, that's, I don't think there's any gray area around that. I just don't see those because I think those are either there's already a petition filed or you know, it's happening close enough to where the, you know, the attorney's already connected with the youth. But secondly, with regard to what Shannon was saying about cost, one of the things that was really helpful for me in looking at the data that Gloria pulled was, this is, you know, we're talking about a pretty small percentage of caseload that's pre-petition. So I feel like, I mean, that was one of the things I wanted to do was get a handle around how much of our caseload are we paying for pre-petition, so that we can, because right now it's not built in, you know, we haven't factored that into any type of caseload projections that we have done for our PCRP counties. And at this rate, there isn't much additional to factor in. So that's the good news is, in terms of numbers of cases, we've got some room for a little bit of expansion. But we also can't, suddenly, throw the gates open and say you can request anything you want as pre-petition because there still needs to be some rationale and legal basis for us to authorize those. So I am going to call, I think, Paul, I think you had your hand up first.
Oh, thanks. I just, I was reading example number 1 here, and I thought, oh my gosh, this is mine. And it kind of is until, DHS reaches out to PCRP attorney asking them to represent a youth whose father recently passed and mother is temporarily out of the picture following previous DHS involvement. Youth is living with a family friend of the father. DHS believes youth's current situation is best for the youth, and then stop there. And instead of the remainder of that paragraph, DHS believes that it doesn't have to, that it can do visitation, require mom to participate in services, sign releases of information, and prove that she's fit without filing a case. So now there is an assessment, but I just thought it was interesting. The agency would exercise their interfere with the parental relationship by essentially making the parent responsible for all these services, and as if the parent was court ordered to do them, but yet DHS absolves itself of all duties and responsibilities that they would have if they filed a petition. So interesting is all I can say.
Right. Yeah, and I knew some of you would recognize some of these, and I've changed details a little bit again to to protect the innocent. But
so it's actually the opposite. I guess my point being is that I'm going to make DHS file a petition, or I'm going to file a petition because so it didn't actually. My point being is that it actually is going to lead to a petition being filed. So sometimes these fact scenarios, my point is they're so different and strange and unique that they don't actually prevent a petition from being filed.
right.
For no fault of the parent.
Right.
Yeah, that's all.
And I think one thing to point out in this, and I actually have pointed it out down below, is if you were asking to represent a different party in the situation, our answer would likely be different. So, in example number 1, if the request was to represent mother, the answer would likely be different.
Right, and if the request was to represent the teen child who wants to stay where he is after his dad died and wants nothing to do with his mom, the agency would say no, or yes, or qualified.
Yeah, I mean, yeah, qualified, I guess, because again, it's like who's the subject. Currently, if we're focused on who the subject of the investigation is, then it would be, we likely wouldn't be able to prove that. But clearly, if they didn't want child with mom and mom becomes the subject of their investigation, then that would pretty clearly align with our current guidance. An example, I don't think I even read example 2, but example 2, former parent client reaches out to PCRP attorney asking them to represent him to gain custody of his son who has been living with him for several months. Mother still has custody, and there's a new assessment as to mother's younger child with a different father. So if the former client is not the subject of the assessment or investigation, so our answer has been no on those. But if request was for the mother, it would be approved. Or this is another situation where it could be claimed a different way. If the request had come in while father was still an active client, and there was a petition, you could ask for a complex case for the, for helping with the custody paperwork. And I do get a fair number of requests for that, for assistance. I mean, oftentimes it seems like getting custody in place is the one remaining factor before they'll dismiss the dependency. And if that's the case, we have been approving that work as essentially complex related legal needs. So you'll get an extra case count. It's obviously not pre-petition because there's already an ongoing petition. Is anyone not aware that that's something they can request additional case count for? And I'm sorry, I see hands. I'm going to call on you in a second.
This is Stacy. I was not aware that that was a possibility. Is that for public defenders as well as consortium members?
Oh yeah, it's for any PCRP attorney.
Okay.
And again, go ahead and reach out, but I mean, we have pretty routinely been approving those. All right, Melissa, I think you were next.
Thanks, Caroline. So I know that currently your numbers are saying that it's a really small number of pre-petition requests for representation, but I think as word gets out around the state, I would expect that that number is going to increase, particularly because once community partners start to become aware that that's an option, they are going to be directing people to us for that purpose. And then the other thing I would say with respect to youth and delinquency cases, a lot of times if I get that phone call, it's because my client, my former client, or the youth is being interviewed like immediately by law enforcement, or they're in the car on the way to the police station. I don't have time at that point to contact OPDS to seek authorization. And so my position is that I just represent them pro bono at that point, unless and until I'm appointed. And so, because I think it's more important, frankly, that their rights be protected than I get compensated, frankly, for the work that I'm doing. And I think it's important too, the same thing happens when DHS shows up at someone's house. I mean, I've actually been on the phone with a former client when DHS is knocking on their front door. And so we don't always have the luxury of time to seek authorization. And so I think that the actual numbers might be higher than what your reports reflect.
Okay, no, that's a really good point. And I'm, we certainly appreciate, you being available to do that. Again, on the delinquency side, I think that's absolutely appropriate. And obviously you don't have time to reach out to us. And I guess my point is those are sort of a given, but you should claim them. And the reality is if you're not going a whole month before a petition's filed, then you're just going to claim the new case, right? But if it's preventing a petition from being filed, you can still claim that for the month that you did the work. But it's partly up to you. If it's one visit and one conversation and the matter's resolved and you don't feel the need to ask for a case count, that's fine. But I don't want providers thinking they can't, because that's work that you wouldn't otherwise be doing. I noticed Paul commented on your commented on the comment about once the community partners become aware of this, and he's absolutely correct. Well, you probably noticed the high numbers in Columbia County, and part of that is DHS is the one reaching out. And it's one of the things that although a referral from DHS doesn't necessarily mean we're gonna deny it. It is interesting that we hear from different counties that these pre-petition matters are coming to them through different means. In Columbia County, most of them come from DHS. I mean, obviously some previous clients are reaching out to their attorneys, but had to have a conversation with Columbia providers that, like at some point we do need to let DHS know that you are not their lawyers, that that's not how this works. They don't get to call you up and assign you these matters. Whereas in many other counties, they're only coming to the attorney's attention through their either current clients or former clients or family members. And DHS is not involved. So I hear what you're saying, Melissa. I don't, again, and it's part of why we can't open the floodgates. We can't say, DHS reach out to attorneys anytime you're taking a look at something because they'll be able to help you. I think we do have to continue to draw some bright lines around, guardianships where there's no active investigation of any sort. But I do want to hear from others that have their hands raised. So Gardner, you've been waiting patiently.
Hi, I think I'll just two quick things. One, it was my understanding that the notion of PCRP was better outcomes being the primary goal for these families. And when I think of families, I think of the individual pieces of the family. So my question is this: if we're trying to get better outcomes for the people we would represent in an open case, in other words, I'm representing a 16-year-old boy, Melissa's representing a mother, Amy's representing a father, then pre-petition, it seems that the logic would be that every one of those representations and what they would want in an open case would be appropriate discussion for pre-petition appointment. In other words, if a mother would want a case open to add protections and supports in her that she's not able to get some other way, wanting a petition, as I think it was Paul that mentioned that, the idea of trying to get a petition from DHS actually being filed, seems like it'd be appropriate for pre-petition work, unless your only goal was to save the state money and to stop petitions from being filed. In other words, I was trying to understand the logic of why, if the goal is representing a 16-year-old kid in an open petition case that's already filed and is moving along, and they want mom and dad to have to deal with this case being open, and they want that support, then if that kid approaches you prior to that and says, can you help me here? I'm in a tough way and DHS doesn't seem to be doing anything. Why is that? I'm just wondering what the short version is why are those not all appropriate pre-petition appointments in dependency cases? Does that make sense?
I think so.
I could say it more simply. If it is appropriate to pay attorneys in the PCRP program to represent a kid who wants X in an open filed petition-led case, why would it not be appropriate to ask for a pre-petition represent for a kid who wants X to occur, but it can't occur until a petition is filed and a case gets moving?
I have thoughts on that. Shannon, do you want to respond? Oops, you're on mute.
Again, if it were a limitless pot of funds, I would probably figure out where to draw some lines around this, because it's not an unlimited. And so, that's my I'll say. I think beyond that, it's looking at.
I'm not sure if others are having the
a
same
hard time hearing you.
difficulty,
You're
but
kind
I'm
of
not.
coming in and out.
Thank you. I wasn't hearing the audio off and on there.
Nor was I.
All right, I'm not sure. I'm gonna lean really close to my laptop now, because I think I didn't bring my headset today and I always have some audio issues. Can y'all hear me okay right now?
Yes, that's better.
I'll back up and restate what I said earlier. That if it was an unlimited pot of funds, I might tend to agree with you, Gardner, but it's not an unlimited pool of funds. This is really it's part of the contract, but I almost think about it as sort of above and beyond sort of representation to try to, as you said, achieve better outcomes, because I think if you can get without the filing of petition and the litigation that goes along with that, that's better for generally speaking, everybody involved is better for the system. There are a lot of reasons to be, approving pre-petition representation, but there are some lines. So similar to what I said to Amy earlier, I think it's looking to what is the threat. Like when I look at this example one on this denial slide, that I'm not talking about, but that one, when I look at that, I don't see the threat. If we don't approve pre-petition representation to assist with establishing this child, it looks to me like while that might be a good idea for there to be a guardianship, this status quo is just going to continue. There's no looming threat of a DHS intervention. It might be a different situation. I'm not saying we would approve or deny in this situation, but it would be a very different situation if you have mothers sort of knocking on the door and saying, I want my kid back. That starts to look, that would be a different situation. So again, say too about the sort of, investigation. If you have an active ongoing assessment investigation, whether it's a youth or in a delinquency case or in a dependency case, the example that Paul gave earlier of DHS trying to intervene and direct the parent to do something, and I think you could see something similar with, probably far less likely based on what I know, but where you're wanting to, and I don't think about it forcing DHS to file a petition, but really pushing back whenever they're trying to do things that they're not entitled to do and infringing somebody's rights in a way that they're not, I think constitutionally and statutorily allowed to do. You're really defending that person's rights against state interference.
Can I ask a follow-up question to that, which is, in that case, you're saying that it would be appropriate for you to get appointed counsel pre-petition to enforce constitutional rights of a kid who working with that kid, you want the mom somehow to assert her rights that DHS can't voluntarily force her to do all these safety planning and stuff, and they need to file a petition. In other words, it gets garbled if you're saying that what you want is DHS to do their job regarding the mom, and to do it right legally, they should file a petition, but they're trying to do it short of filing a petition. So how do you represent or encourage another party, mom, to get that case, either to get DHS to leave her alone or to get DHS to step up their involvement if you're not allowed pre-appointment under those circumstances? What are you supposed to do as a attorney? You're not allowed to do anything, is that correct? Under PCRP, you shouldn't be working on that case if you're not pre-appointed, right? I'm sorry, I can't hear you.
I think that's a situation where we have approved pre-petition representation.
That's correct.
Parent who's being investigated, there's an active ongoing assessment and DHS involvement. It's just the way they're going about it is not lawful. And so that's, I was just trying to give some balance to sort of in how we try to think about this, and what the guidance is, some of it is looking at what is the threat, what is the likelihood DHS actually proceeding and filing a petition. So in that, I think about it with, looking at like example one here, as I said, that looks like.
Shannon, you keep breaking up really badly. I'm sorry to interrupt you.
Yeah,
I'm going to back up and I'll let Caroline take over because I don't think y'all are going to be able to hear me.
I was just going to say that was going to be my response on that as well, Gardner. Is I think it's just a matter of who is getting the representation. So it would be, if mom's the subject of the investigation at that point, that's who we would authorize the representation for. And I would have to say, honestly, other than the situation that Amy's referring to with the youth, typically the requests that I don't recall a situation where I've received a request to represent more than one party in a pre-petition matter. I mean, typically the request comes in. It's sort of like the party in a pre-petition matter is either the, should be the subject of the investigation, or whereas when the petition's filed, you have all the parties, the children, the parent, each parent. And so that's how it's coming to our attention. I want to be cognizant of the fact that we've only got about 8 minutes left, and we've got more people with their hands raised. So Jillian, you've had your hand raised patiently.
Thank you. So I, as a case manager, have worked on a number of pre-petition cases in Columbia County, and I had just wanted to kind of touch on that idea of, the agency referring and what that can look like sometimes. Because what I've seen a lot of times is that, especially like in my work with parents, it may have a lot to do with a parent who is not engaging with the agency. And so rather than whether or not a petition gets filed down the road or not, I think that what is often hinging in the balance is whether or not an in-home plan can be put together. And I think that so many parents have, especially if they have any kind of historic history or just in general, so much confusion and fear around what's going on with an assessment, that we have these tremendous barriers around the fact that the agency is not able to put together a safety plan, and we're seeing cases come into court. Whereas many of those parents have a really clear understanding of what the role of an attorney is. And I've had a lot of success in engaging parents by working with that attorney office. Those parents, those barriers to engagement break down a lot quicker. Turns out a lot of these folks do have some supports. We can put together some safety plans. So I think just kind of keeping in mind that in-home plan piece really comes in with the pre-petition.
Thanks, Jillian. And that's a really good point. Although we don't see a large number of case referrals, again, because it's a finite resource, but you certainly can request case manager assistance pre-petition. And I know there has been some good results with that. Let's see, Alan, did you have your hand raised?
I do. I'll be very quick. This has become kind of a hot button here. I'm in both Benton County and Lincoln County, and one of our colleagues actually raised the issue and challenged reasonable efforts to avoid removal because DHS did not refer the parents to an attorney to help address the issue beforehand, which has made a bunch of questions come up, but definitely is something to consider. I've talked to both the AGs that represent in Benton County and here. One of them actually said, why would we ever want to get parents gearing toward attorneys? Because all that does is spoil our, well, so to speak anyway, but basically gets in the way of our gathering, making our case. All of a sudden lawyers get involved and now they're not going to sign releases, they're not going to do this and not going to do that. So anyway, but I really wanted to raise up the point where that one attorney made that argument that they did not ask for get attorneys for the parents, and therefore they didn't meet reasonable efforts to avoid removal. So one last point was all this kind of made me think of maybe getting the lawyer referral, the 800 number with the bar, to have a list of PCRP attorneys in these counties in case a parent who definitely has a case and definitely is out there looking for a lawyer, that would have a way to get a hold of a PCRP lawyer anyway in their county. So there, that said, I'm done.
Thanks, Ellen. Paul, do you have your hand raised again, or is that left over?
That must be left over.
Okay. And let's see. Melissa, is your hand raised? Sorry. It's still
No,
showing.
I think I put it back down. Maybe not.
I don't see it up next to your your picture, but when I look at okay. I just wanted to make sure I had everyone.
I was gonna add though that when you have a parent who is having initial early contact with DHS due to an investigation, the parent may not know whether they themselves are the subject of the investigation or someone else. And so I do think it's important to take that into account, that parent still has an interest and has constitutional rights that need to be protected in that situation. when we're looking at whether those requests should be approved or not.
Thanks, Melissa. No, that's a really good point, and that's certainly something that Shannon and I were talking about even just this morning about, in terms of, again, we still think there's a pretty bright line about we can't authorize representation for guardians who aren't, for purposes of finalizing a guardianship where there's not an active investigation of any sort. But in terms of being able to extend pre-petition representation to other parties, and this kind of goes back to what Gardner's talking about, other parties where there is an active assessment or investigation. They may not necessarily be the target, but it may make sense for us, to begin broadening that scope so that the criteria really is limited to, is there an investigation or an assessment? And then, maybe it's both parents, get pre-petition authorization. Part of that, like I said, I honestly just haven't seen a lot of requests for multiple parties in pre-petition matters. And in some cases, it's very clear who the target is of the investigation. But clearly I imagine there are situations where it's not. Those just aren't, for the most part, coming to our attention. Unfortunately, we are out of time for today. And so I'm going to suggest that, we can certainly wrap up any final comments at the beginning of our next session. But I will, we'll look at taking a look at whether we can propose a recommended adjustment to, it may not even require an adjustment to the contract language because the contract language may be broad enough, but our internal guidance on what we approve. And then we can take a look at that as we start our next meeting, because, we'll obviously want to move on to our next topic as well.
Hey, Caroline.
I just wanted, oh yeah.
I have a quick question, because I keep hearing, not just like in this setting, but in other settings, internal guidance. Is that like written somewhere? Because it's hard for
and I can
providers to know like what the internal guidance is and upon what it's based. Does that make sense?
Sorry, yeah, it was just under the definition. So right here, eligibility determination guidance.
Right, but I
It's
mean,
just
like in
we're-
general, is there like some manual, handbook, something like that? Because it seems like I'm hearing that more and more, like for NRE requests, and I know that's a separate topic. But these eligibility determination guidance, like, is it written out? Is it something that would be helpful for us to know, like, so we can make sure we hit on those issues when we're making the request to save time for everybody in the long run?
Yeah, honestly, I can't speak to NREs, that's handled by something entirely, an entirely different section, but for purposes, for purposes of pre-petition requests, it's simply, guidance that helps us interpret, what the contract definition means. So it's not written anywhere else other than, again, we have it in emails. It's what I've sent out to individual attorneys when they've asked for it. And I've put it here, but it's not, we don't have it in a handbook anywhere. I just wanted to remind folks of the next meetings. And Amy, I see you have a comment. Yeah.
I know you guys are busy, but to the extent that we can get materials in advance so that we have time to really think through them and ask, I'd love to get a chance to staff anything that's proposed with folks in our office who are actually doing the work and may see more of it than I. I'd really appreciate it. So if we could get any proposed language or any proposals like a week in advance, that would be great.
Sure. Yeah. And we'll talk about whether we, internally with our team, whether we we might propose something in the materials that we send back prior to the meeting, and then we can't, obviously we can't participate in dialogue over email. We'll need to keep that discussion for the meeting, but you can certainly get input from your staff. And let's see, we've got, I see a hand. Oh, Michaela.
I know we kind of ran out of time for this meeting, and I think we also ran out of time a bit in the last meeting. I'm just wondering if an hour is an appropriate amount of time to be able to engage in the type of dialogue that we all would like to have. I just wanted to throw that idea out there.
I mean, unfortunately, I think we're sort of limited to an hour. It's interesting because at one point I wondered if we would need the whole hour, but apparently, clearly we do. So I want to be sensitive to that. But again, I'm happy if there's anything that you specifically that you'd like to talk about to finish this topic at the next meeting, feel free to reach out and I can include that on the agenda for the next meeting. And I do apologize, but we are, I want to be respectful of people's time and we are at 1:03 at this point. So, but Michaela, do feel free to email me if I can include something on the agenda for the next meeting.
Okay, thank you.
Thanks, everyone.
Thanks, everybody. Really helpful meetings. Have a good day.
Bye-bye.